All rise. The Court of Appeals Division 1 is now in session.
Good morning. Please be seated. We're here today in the first matter, Heritage Village 2 Homeowners Association, Richard Weinberg et al. And versus John L. Norman and Jerry Malotsky. I hope I'm pronouncing those correctly. 1 CA-CV18-0193. We're here for oral argument on that. Each side has 20 minutes. Appellant, if you wish to reserve some time for your argument for rebuttal, you're free to do so, but we don't track that for you. It's up to you to keep track of it. This matter is being recorded for YouTube, so when you appear, please state your name and who you represent for the record so that people on the internet have an idea of who everybody is. Is there anything I'm forgetting? Okay. With that, we can proceed.
May it please the court, my name is Doug Northup and I represent the interveners, appellant, John Norman and Jerry Malotsky. I'd like to reserve 3 minutes of time for rebuttal. Unfortunately, the trial court below applied the wrong legal standard on both timeliness and interest and protection of interest elements and erred in not allowing our clients to intervene in a lawsuit that has now been closed and dismissed. Under Rule 24, as the court is well aware, there are 4 elements, and the court must allow intervention if there's a timely motion, the intervener claims an interest relating to the subject of the action.
I understand the prongs of the rules, but let me ask you, on the timeliness component, you pointed out that the action has been closed and dismissed. Let's say that you're successful today and we reverse. Do you have a meaningful remedy, or should this have been brought as a special action?
No, we absolutely do, Your Honor, and I think we had to bring it as an intervention petition. And again,
No.
review
The difference between an appeal and a special action, not an intervention petition and something else.
I believe that the proper remedy here was an appeal because we tried to intervene. That was denied. The fact that the case was dismissed, that happens regularly in almost every appeal. There may be a judgment that's been entered. There has to be a final judgment. The fact that there was a settlement, had we been allowed to intervene, our clients would have been allowed to protect their interests. That wouldn't necessarily foreclose a settlement between the Weinbergs and the HOA.
Well, true, but what does the remedy look like if you're successful today? The case was dismissed by stipulated judgment. Normally, when we reverse a judgment, we reverse the judgment on the merits and it goes back for further proceedings. Here, we can't really reverse the settlement.
We're not asking that you reverse the settlement in total, but it would be no different, I don't believe, Your Honor, whether it was special action or an appeal, to reverse the judgment that was entered, reverse the dismissal of the case, and allow it to proceed. And at that circumstance, again, had we been allowed to intervene, the HOA and the Weinbergs could have settled, but we could have protected our clients' rights, which we were unable to do and wouldn't be able to do in any type of a separate proceeding.
So if we reverse the judgment or the order denying intervention, don't we have to reverse also the judgment approving the settlement?
I think you would, because that would have to be revisited. But again, it's not a matter that the HOA can't settle. They can't settle on terms like happened here, where Judge Gamma's ruling following 3 days of evidentiary hearings were vacated in a way that's very prejudicial to our clients.
Why couldn't they? Even if you were allowed to intervene, couldn't the court still decide that the settlement was appropriate and approve it?
Well, it could approve the settlement as between the settling parties, but that's the whole reason our clients wanted to participate, because the settlement did not protect our clients' interests. The HOA essentially gave up. They didn't argue that this was a good settlement or the CC&Rs were being enforced. They said, we don't have the money to fight it anymore. So instead of...
And in truth, the court never approved the settlement. right? The court didn't review the merits of the settlement. It just accepted a stipulation.
Right. They just accepted a stipulation to dismiss. And again, you know, this isn't one where forever the HOA is locked in litigation, but they essentially said, we ran out of money, we don't want to fight anymore. And I think that certainly illustrates the lack of protection of our client's interest, because if you can't afford to protect your own interest, you certainly can't adequately protect someone else's interest.
So then let's talk about how that shakes out practically, and I use the word practically advisedly because it appears in Rule 24. If we affirm and you bring your own independent action, how are your interests practically impaired?
Well, first of all, we argued that a separate action would impair our interests, and in fact, the appellees conceded that, because their position is there is no right to a separate action. And they didn't even argue to the contrary, and that fact is frankly conceded on appeal. But if we get past that part of it, Your Honor, there are a lot of interests that can't be protected, most notably the fact, again, this wasn't just some settlement that left anything intact in the prior case. Part of the stipulation was that Judge Gamma's and even Judge Heggie's orders on the merits were vacated.
So your argument is that you have an interest in not only enforcing the CC&Rs, but an interest in enforcing the rulings that were entered into this litigation before you intervened?
Absolutely, Your Honor. If the HOA would have said in 2014, we're not going to take this on, our clients could have acted then. Things are timely, witnesses' memories are fresh, but there's been a lot of water under the bridge, including, and I'm sure the court has reviewed Judge Gamma's rulings, he had a 3-day evidentiary hearing where he found there were serious violations of the CC&Rs. He made credibility determinations of witnesses. He awarded attorney's fees that were substantial that our clients paid a portion of. And you can't just go back and undo all that and say start over again now in 2019 in a separate action. There's no doubt.
Why not?
Pardon?
Why not?
Well, for one thing, the appellees have made their position abundantly clear that they don't think there is any right. They would fight that tooth and nail. There's little doubt that they would argue that the settlement and things that were found were res judicata or would otherwise preclude our client's interests. And again, Your Honor,
well, but how could you have res judicata? You can't have issue preclusion because the settlement does not represent actual litigation. It's just a stipulated judgment. And claim preclusion, there was an effort to bring in indispensable parties that was denied. So I'm having a hard time seeing how any species of res judicata would apply.
Well, and I'm not conceding that it does, but when our opposition is arguing you have no right at all to bring a separate action, and the question, Your Honor, in Rule 24 is whether the interest, which I think Judge Heggie assumed the interest, he said it can be adequately protected. I don't think there's a very strong argument at all that our clients don't claim an interest, but the rule says that interest may, as a practical matter, be impaired or impeded. It's a very low standard. The cases, the Western Energy case, talks about if it's possible, your interest may be impaired. Not that it may or it will. It's possible. The Utah Association of Cities case that we cited the question, is it practical harm, not even legal harm? So the fact that we're having this debate about what the effect might have, I think illustrates that under the liberal standards that are being liberally applied, as the cases we've cited say, shows that we should have been allowed to intervene in this case, because we cannot protect the interest. We can't, again, when you've gone through this much time and the effort and the work that's been done, and to have those findings and those rulings just vacated and say start all over 5 years later.
But done not by you. I understand the argument that if you had expended all this effort, it would be wrong to deny you the benefits of that effort. But it was work done by someone else. I don't understand why your client should necessarily get the free ride on the, not free ride, that's a pejorative term, which I don't mean, but why your client should stand to benefit from the work done by the HOA.
Your Honor, our client paid for that work, as did all of the members. Our client, under the CC&Rs, had the ability to take action directly to protect those interests. Some CC&Rs don't allow that. Having allowed the HOA to move forward and do what HOAs are supposed to do, and not taken direct action, and in fact, if they would have tried to intervene sooner, the argument would have been the HOA is adequately protecting your interest. That's the reason, Your Honor. They did participate, at least indirectly, and had they tried to protect, just based on the ruling that was mentioned here about indispensable parties not being allowed, the argument would have been the HOA's got it covered, you all stay out. And that's what happened until July of 2017, when our clients learned that instead of, going from vigorously enforcing the CC&Rs and pushing forward with a reasonable resolution of the underlying case, that the HOA just gave up. They had a board change and basically capitulated to the Weinbergs. And at that moment in time, our clients could not rely on the HOA to protect its interests anymore, and properly said, we need to intervene in this case while we still can and while we can still have an effect. And unfortunately, when Judge Hagee said, well, the separate action can protect your interests, we know it can't. And then he also went further, and on the timeliness, he in a cursory fashion said, well, I don't think this was timely, but then goes on to say, assuming it was timely, the association has borne the cost of this litigation for years without direct assistance by interveners and is entitled to bring its costs and aggravation to an end. There was no reason to say that if he was relying on anything other than the incorrect legal standard, as was the case in the Ziani
Even if
matter.
you're allowed to intervene, the HOA can bring its costs and aggravation to an end. It could still settle separately with the other party as well.
Yes, and it was surprising to us that the HOA, having so vigorously prosecuted this and followed the findings that Judge Gamma found these serious violations, didn't say, come on in, we welcome you in. In fact, the HOA's association, who had represented him throughout this litigation, filed a joinder saying, I think they should come in, and what happened is he was promptly fired and replaced with new counsel. So clearly that's the case in this situation, Your Honor, and I agree with that.
I would caution all parties and people in the audience to keep when you're at the podium, you can talk, otherwise don't make audible comments.
And to continue on, Your Honor, the Ziani case and many others that we cited, there a motion to intervene was denied on untimeliness. It was a case that had been going on for several years, and the court there said the trial court used the wrong date as a starting point for determining the timeliness of the motion. The court should have used the date on which movements knew or should have known their interests in this litigation were not being adequately represented by the HOA, not the date on which movements knew or should have known about this litigation. And I think Judge Hagee's language on the timeliness illustrates that he followed that wrong standard, because there would be no reason to talk about the aggravation and the costs and the timing of the litigation otherwise. The only other fact that appellees rely on is they said, well, Mr. Molotsky was removed from the board in December of 2016, and therefore that should have somehow put him on notice of something. I'm not sure exactly what. There's a whole lot of things there where they talk about these, facts that were really undisclosed secret negotiations toward the settlement that our clients didn't know anything about. But I do want to make sure the point is clear. Two members, including Mr. Molotsky, were removed from the board and replaced with two other directors who vigorously supported not just litigating for the sake of litigation, but enforcing these CC&Rs. So that replacement didn't put them on notice of anything. And in fact, even in June of 2017, about almost exactly a month before our clients moved to intervene, the association opposed the motion filed by the Weinbergs to vacate the attorney's fee judgment. They would continue to prosecute this, and it wasn't until our clients learned on July 7th.
How do you have any interest accepting for purposes of argument that you have an interest in enforcing the CC&Rs? Why would you or your client have any interest or dog in the fight regarding the attorney's fees award?
Well, I think that the homeowners were the ones that paid those fees. The association doesn't do anything. It's funded entirely by its members, and I think that in these circumstances that one member on behalf of other members could assert that, but the interests here go far beyond the attorney's fees. It goes to, again, look what happened here. There's a settlement
you
now.
said that,
Yeah.
Assuming you have a right to enforce the CC&Rs and possibly even enforce or have an interest in the initial findings regarding a violation of the CC&Rs, why the attorney's fees?
Again, our clients paid one whatever fraction their ownership is of the total owners in the association.
But they wouldn't get that back, even if the attorneys.
I think they could get it back, again, whether or not they could get it back on behalf of the association with the settlement, I'm not 100% sure how that shakes out. The crux of the harm is not just the attorney's fees, though. I think they could seek to recover the attorney's fees that clearly had been awarded and were, almost, I think under most any scenario, is going to get ultimately awarded at the end of the case. But even aside from that, the real interest, and you said, Your Honor, assuming for the moment that they can enforce the CC&Rs, Your Honor, Article 3, Section 1 specifically says, these restrictions may be enforced by the owner or owners of any lot, and further, any owner or owner shall have the standing and right to enforce the provisions of this declaration, articles, bylaws, and rules and regulations against any other owner or owners. And that's all they wanted to do. When the board went from having achieved near total victory, had been vigorously enforcing these CC&Rs.
Doesn't the other side contest this total victory concept? I mean, I agree that the Judge Gama found that there was a violation of the CC&Rs, but he had basically said, now you guys go figure out what the remedy of that violation, and that seemed to be a very contentious issue going forward.
Well, and they do contest that. But the forum for having that contested would be in the trial court lawsuit with my clients being parties and being able to represent it, not with an HOA who had been vigorously enforcing it and who had been vigorously arguing it was total victory and that they were going to require substantial changes, suddenly saying, we're out of money, we're out of grit, we don't want to fight this anymore, we give up. So yes, those would probably be disputed facts about what the remedy and the relief might look like, but that's the whole reason that we're here today, is we didn't get a chance to make that argument because of the dramatic change that occurred in July of 2017. So all in all, Your Honors, we've met, I think, clearly all four of the elements. The interest impaired, timely motion. Our clients moved incredibly quickly within 5 days after the settlement being approved, which was on the heels of 3 days earlier.
Approved by whom?
The board in executive session, but only 3 days before that, we learned the board said, we're not going to settle this case because the Weinbergs won't make any meaningful changes to their home and aren't going to pay any attorney's fees. So that 5-day period, there is no case law that wouldn't suggest that type of a period is timely as a matter of law. And I think it's unfortunate that Judge Hagee did what many courts in the cases we've cited have done and focused on how long the case had been going on, not how long the time elapsed between our clients learning their interests weren't being protected and moving to intervene.
So coming full circle, the remedy you seek really is a vacation of the judgment of dismissal and a reversal of the order denying intervention. But that remedy need have zero effect on the settlement itself.
Well, whether it does or doesn't, we would certainly contest whether if the agreement contains the provisions about vacating prior rulings and things like that. But at the end of the day, can the association move on and settle and get out completely if it wants to? Can it ride our clients' coattails? Absolutely. But we just need to be able to protect our interests that were so long protected that suddenly weren't. I'm about to run out of time, but lastly on fees, Judge Hagee properly denied fees under the CC&Rs, but I think he has expanded 12-341-01 far beyond any decisions of this court or the Supreme Court. And the one case he relied on was not a 341-01 case at all. It was a product liability case that arose under the fees were 12-349. So unless Your Honors have any further questions, I'd like to reserve the rest of my time.
Please do.
Thank you.
May it please the court, my name is Scott Holcomb. I represent the Heritage Village 2 Homeowners Association. Also with me in the courtroom is the board for the association, members of the board, and also Mr. and Mrs. Drott. And the reason that's important is what we were just talking about here, about what the remedy is and what would happen in this litigation if the proposed interveners were allowed to intervene. The HOA board, which has the sole authority to determine whether to settle a lawsuit or not, that it brought and prosecuted for a period of 3 years, and now it's been on 5 years, they have the sole authority under Arizona law and under the CC&Rs that are meant to be enforced. And I want to clear something up because there was a major misstatement, and I don't think it was, I don't know if it's intentional or not, but there's a major misstatement made here in that the association argued that they couldn't bring an independent lawsuit. We argued the exact opposite. On the response that was filed on August 10th by my office, on page 2, because we're going through our 4 arguments, the 4th argument was proposed interveners, excuse me,
Sorry.
bless you.
Thank you.
Proposed interveners failed to inform the court that on July 6, 2017, they filed essentially the same complaint in Maricopa County, Arizona Superior Court, case number 2017-009249, the prior complaint, copy attached as Exhibit 1. To the extent proposed interveners have any rights which they need to assert, they can do so in the suit they have already filed, but they cannot force HV2 against its will to continue to litigate a case that HV2's board has already agreed to settle.
Is that necessarily even the consequence of intervention? All the intervention seeks is the status conferred by Rule 24. If you have a case with multiple parties on one side, they can split, take divergent positions. Some can settle, some can remain in the lawsuit. All this sole authority business seems a little bit misdirected when there's nothing to suggest that the board would not be able to persist in its decision to settle.
Well, their decision to settle, but there's 2 parties to a settlement.
Right.
The Weinbergs, they were settling from their stand, to bring an end to the litigation. That's what settlements do. And that's why this court has
litigation between the parties to that litigation. Now, if that list of parties expands, there's nothing to keep the Weinbergs from settling with the association, nothing to keep the association settling. And as far as I can tell, there's nothing in this appeal that empowers this court to in any way interfere with a separate agreement the parties have reached to settle the case.
Well,
the only question is whether the putative interveners can pursue their claims, right?
And they can pursue those in a separate lawsuit. So that goes to their interest. They argued that we have.
I mean, I understand the rhetorical sleight of hand there, but my question was not really whether they can pursue it in a separate lawsuit. My question was whether their intervention has anything to do with the arguments you're making.
And it absolutely does, because what they sought was to, and they changed the position, what they sought was to stop the settlement from being entered into. That's what they argued below. We filed this lawsuit to stop the settlement from being entered into, because they argue that if the settlement was entered into, they would not be able to enforce their rights. And I want to really...
And nothing pending before this court today even raises that as a possible remedy, right? We can't stop the settlement from being entered into. All we can do is decide whether the case goes on with the interveners as interveners or not.
But, Your Honor, and that is, I think, a very important point, because we have to look at what remedy they're looking for, and what the remedy is under the CC&Rs. Okay, throughout the documents are called the ACC&Rs because they're amended, but the ACC&Rs, which are Exhibit 2 to Index Record 209, and is admitted in the opening brief at page 9 and page 10. The relief they are seeking, the violations they are seeking, are violations that are determined to be violations or not violations by the board, not by individual landowners. It's in Article 3 of the amended CC&Rs that governs the architectural control, because that's all we're talking about here is architectural control, whether or not they submitted the plans to the board and the architectural committee before building. The individual landowners, they can report to the the architectural committee and the board, which is in essence the board now. But the board makes the decision whether or not to approve the plans, and only the board. The individuals do not approve or disapprove those architectural plans. And in fact, if you look at page 10 of their opening brief, here's what they allege the violations were. The violations were erection of a dwelling that is 19 feet high, when most HV2 dwellings are only 12 feet high and the highest other dwelling is 17 feet high. There's no height restrictions in the CC&Rs. That's determined by the board.
This seems far afield of the issues we have before us. This goes to the merits of a case, whether it's heard in this action or a separate action, that we have no competence based on this record to decide. So where are you going with this?
Where I'm going with it is going exactly to where their interest is. What would you ask as a practical matter? What would happen if this case went back to the trial court? Mm-hmm. And what would happen is they go and they would seek to enforce those provisions of the CC&Rs. Well, enforcement of those provisions of the CC&Rs, the ones that they have identified, which are before this court, all go to approval by the board. The board has already approved them. In fact, that's what the settlement prepares for. The settlement goes through and talks about, we are approving. This is how you comply with the CC&Rs.
Your argument right now seems to be that their case, if allowed to proceed, would lack merit. Right? And that doesn't seem to be a consideration under the rules.
No, it goes, Your Honor, I respectfully disagree. I think where it goes to is the exact question that you ask. Okay. And that is, what interest of theirs is being impacted by the settlement and the litigation.
You keep saying exclusive authority, which makes me confused, because you started off arguing that they have an independent right to enforce the CC&Rs. Do you agree with that?
No. What I argued was that they have an independent right to file litigation if they believe that they have a right.
Everyone has a right to file litigation.
And in the CC&Rs, it say individuals may enforce the provisions of these CC&Rs. No.
And then you said that the board has the exclusive right to determine if these architectural plans are in compliance with the CC&Rs. Those seem to be inconsistent arguments.
No, they're not inconsistent, because there are other provisions, such as Article 2, Section 6 of the CC&Rs, which go through and say, trash, traffic. There's like every set of CC&Rs, they have a listing of things that you can and cannot do, and those can be enforced. But specifically to the violations that they're talking about are violations of the architectural control provision. And the architectural control provision says you have to submit the plans and they have to be approved by the board. So that's what I'm getting at. The specific violations, they could go, if there was a parking violation, they can go and enforce that separately.
So why wouldn't then the correct result be that they have asserted an interest in general, at writ large, enforcement of the CC&Rs. So they have an interest there, and therefore they can intervene, and it's going to be up to the trial court to determine whether they can actually do the things you're talking about on the merits of the litigation, on whether their interest is something they can seek to enforce.
Well, that's, again, but they're trying to force us to continue a litigation that they can go forward, and that's been a consideration.
That was actually my question.
Huh?
Not all this business about the merits. That was my question in the first place. How can they force the association to persist in the lawsuit? The association can sit on its hands, do nothing, proceed to settle as the association. It doesn't have to do anything, right?
Well, we're still parties to that litigation.
Not if you settle out.
Well, we settle out. The Weinbergs have already performed in the settlement, and the settlement that we've entered into provides that the CC&Rs, that these are the requirements that are necessary by board approval to comply with the CC&Rs.
And they can. You guys have established your position, and can't they then say, "But we disagree with that position, and we're going to assert our rights, whatever they may be, under the CC&Rs to contest that," and then it'll be between the Weinbergs and the Molotskis on whether that is right.
Right, which is what they did in the separate lawsuit that they filed, and then they dismissed. So why continue on this litigation? And we'll at least have to go through. We'll have to work out what the Weinberg's position is on the settlement, as well as getting the homeowners association out in this litigation when we've settled this litigation in total. There's no need. That goes back to whether their interests will be impaired.
Well, you settled it only because the intervention was denied, right?
We had actually entered into the settlement agreement before they filed the
The
intervention.
settlement agreement wasn't implemented and concluded until the intervention had been sought and denied.
The final, correct, the dismissal was not.
Say, well, we've already settled it, I guess goes back to my first question to Mr. Northup about should this have been a special action. But I'm not aware of any authority that says it must be.
I agree that it should have been special action at that point. I do believe that's the appropriate remedy. The key here is that this is a settlement of a lawsuit that was brought by the homeowners association. They paid for it. They were in a situation where it was going to go on for years. There was no total victory. There was no final judgment. This court had actually ruled specifically on that, said all those issues remain to be resolved.
But again, if you lose this appeal, what does your client actually have to do? It seems to me that if you lose this appeal, your client is not compelled to litigate anything.
Well, if you grant the appeal, then you'll be setting aside the dismissal of the lawsuit.
Which could be reinstated as between the settling parties the next day.
If the Weinbergs agree. There's two sides to this dance. The Weinbergs were settling with the association to bring an end to the lawsuit. You're now saying, well, the Weinbergs are forced to settle when the lawsuit is not over. And that drags the association back in. We'll have to fight that issue.
The lawsuit is over as between the settling parties.
Well,
unless the settling parties choose to unwind their settlement.
But that's something, again, that shows that there's no need for this lawsuit to be continued through intervention. They can do what they did to begin with. They can file a separate lawsuit, and Weinberg can defend that based upon the statement of the facts.
So at this point, representing the association, your contention would be that there is no impediment to the interveners proceeding for any relief they could have sought in this action in a separate lawsuit, and you'd be willing, on behalf of the association, to be judicially stopped in any future action from asserting a bar to proceeding.
Absolutely. No, I'm not willing to do that.
Then what's the value of the position you're taking?
The value of the position is taking is what happens. You said anybody can file a lawsuit. They file a lawsuit.
Well, if you're telling this court that sure they can file a lawsuit, but then we'll actually get into their lawsuit and tell them they really can't.
No,
then that doesn't help much.
Would we seek to intervene in their lawsuit? Absolutely not. We don't want anything to do with litigation.
Okay.
We would seek to.
So in other words, and we can ask the Weinbergs counsel this, but in other words, your position is on behalf of the association that the association would do nothing to suggest that the pursuit of remedies in a special action is in any way procedurally defective. No claim preclusion.
Not special action, you mean in a separate action.
Separate action.
Yes.
No claim preclusion, no issue preclusion, no indispensable party problem, nothing. They're free to go. That's your position.
I don't know how they would pursue that. Again, my position is that they're free to file an action.
Well, the freedom to walk into the clerk's office is a fairly meaningless point. I guess I'm asking whether to avoid intervention, the association is taking the position that there is zero impairment to the pursuit of remedies in a separate action, so that the prong of Rule 24 isn't met. Or are you saying, well, there may be an impairment, we just don't know yet?
There may be an impairment, we just don't know yet. But
okay. And then if you follow the language that the 10th Circuit used when interpreting Rule 24, that's enough to support intervention. And
I would like to let my co-counsel respond to that. But the cases this court has held is that when you do it to try to specifically stop a settlement, that's not enough. And if there's the remainder of time, I apologize.
May it please the court. My name is Taylor Young, and I represent the Weinbergs. I wanted to discuss the level of interest that we're talking about here, because we had this discussion about the CCNR saying there's their position that there's an interest in enforcing the CCNRs writ large. I don't think that's the analysis. I think the analysis is, what are they trying to do? What is the interest that they are claiming? And the interest that they're claiming here is a right to enforce harmony and conformity under the ACC.
This is another point. We have fairly little time left in this argument, and I think focusing on the potential defenses on the merits is probably not the way to go.
Yeah, I appreciate that, Judge Swan. The prong is, what is their interest, and so I think that that's the
the prong isn't what is their interest. The prong is their interest practically or legally impaired by the absence of intervention. And what I just heard from your colleague is, well, it might be impaired. We don't really know, and we're certainly not willing to commit to any position that would remove an impairment. What's your client's position?
We're certainly not going to waive any arguments that we might make in a separate lawsuit.
Might be a
of
practical
course,
impairment. And if
Judge
that's
Swan.
so, if there is a possibility of a practical impairment, doesn't that resolve the issue?
I don't think so. Also, because of the timing issue, you have to meet all four prongs, and I'm not going to belabor all four prongs. But
Let's focus on the first and the third. So
Okay,
we
so
talked
the
about
first prong is-
impairment, but first is timing. So
first is timing. So, in terms of timing, the proposed interveners here certainly had notice as of, at a minimum, December of 2016, when Mr. Molotsky was removed from the board, and for reasons, among the reasons that he was removed from the board by a petition, was his that his actions were impairing the possibility of reaching a settlement with the Weinbergs, and he had been, and the declaration of my client establishes that he had been consistently acting to prevent settlement in this case, and he was removed from the board. He did not move to intervene then. He waited another 7 months, before moving to intervene, and that in and of itself is sufficient delay in taking action.
Do you dispute the argument? Because it seems that the record supports the notion that he acted within a couple days of receiving final notice from the board that you guys were going to settle, and the settlement was going to include waiving the attorney's fees award.
In terms of the actual notice of settlement, I don't think we can dispute that. But what we can dispute is the notion that his interests were no longer being represented only as of that date. We can look back to
There was
December.
at least some back and forth, and there seemed to be that the board had voted a couple times to continue pursuing a relatively aggressive approach even after he was removed. So at what point can you point to it and say, okay, separate from him just getting voted off the board, what point did the board officially change its position that he would say, okay, they are no longer representing what I think is the right result?
Well, I think the record establishes that that he knew that his position is no longer being represented when he was removed from the board. I don't think there's I think that's a sufficient time. I see that I only have a minute left, Judge. I wanted to mention one other thing. I apologize. Can I have 2 seconds to grab some water?
Sure, please. And we'll give you a minute or so grace period here.
Your Honor, counsel argued that sort of inexplicably the board fired their counsel, and this was just a coup. That is not what the record establishes. The previous counsel for HV2 was acting directly adverse to the interests of the board. That's why they fired him. And the notion that this is somehow inexplicable is belied by the fact that the state bar has now disciplined that attorney for this exact conduct.
Not record?
No, I apologize, Your Honor.
Please don't mention it.
The last thing that I wanted to the last thing, it is in the record that he was acting against the interests. The last thing that I wanted to mention again is that in terms of the direct interest that they're looking at, the remedial order that we've been operating under was an order that said, as you mentioned earlier, parties get together and resolve this issue through the ACC process, and it was this 6-month timeline where we're constantly in a loop preparing plans. And so, again, just in terms of their direct interest here, I think it's important for the court to understand that what this litigation would look like if they are entitled to intervene would be asserting a right to essentially usurp the ACC, and that can't be a sufficient interest for them to intervene in this case. We would ask the court to affirm the trial court below, and we would refer to the court to our cross appeal on the attorney's fees issue.
Thank you very much.
Very briefly, Your Honors, I want to make something very clear. Counsel started reading from his arguments below about the position advanced. Our position is that on the appeal, that it was conceded that there was not an alternate adequate forum at pages 27 and 28. They conceded that. They talked about below there could be a separate action on appeal, and we said that isn't adequate. They said, oh, there isn't one. So I would refer you to that portion of the brief because I certainly would not misrepresent anything to this court. Also, counsel stood up here and on the one hand said that a separate action might be okay, but then he said in his argument there is no separate right to enforce the CC&Rs. And that's simply wrong. I read to you the CC&R provisions.
I heard his argument of being a little more subtle than that. He said there's certainly provisions that are enforceable, but the specific provision that you guys are litigating is not necessarily independent.
Well, and that's something that the trial court might have been appropriate to argue there, but as we pointed out, it says not only the provisions of the declaration, but articles, bylaws, rules, and regulations. And one thing I would like to point out is the argument that Mr. Young started talking about there, which was the Architectural Review Committee and all that. That argument was not raised at the trial court. That is brand new, and there's nothing in the record that would suggest that the Architectural Review Committee approved this settlement. It was the board that did it on July 7th, at least to my knowledge, and certainly anything that's in the record in this case.
Should we then maybe, instead of reversing, should we vacate and remand for findings on the third prong? Let the trial court actually determine whether you guys have an interest that's enforceable, whether that you have independent standing to either intervene in this case or possibly bring your own action. Doesn't that seem like that there weren't proper findings made below and a proper record introduced below?
No, because under the standards, Your Honor, liberal construction, allowing, doubts resolved in favor of intervention, we should have been allowed to intervene, and then they could make whatever arguments that they want. But I don't believe there's any authority that in determining whether or not we should be allowed to intervene, you make those determinations, because the law, as we've stated, is very clear that if disposing of an action in a person's absence may, as a practical matter, impair or impede that interest, and I think what I heard both counsels say is it would, because neither one of them was willing to stand up here and say that a separate action could even be maintained and they wouldn't fight that tooth and nail. So respectfully, this was a situation where intervention should have been allowed, it should be sent back down, and if the association wants to settle out or whatever they want to do, our clients can protect their interest and do what should have been allowed over a year ago. So if you have any other questions, I'm happy to answer them. Otherwise, I believe I'm about out of time.
You are. Thank you.
Thank you, Your Honor.
We will take this matter under advisement. Thank you both for your presentation, your briefs, and everything today. And we are now in recess while we prepare for the next argument.